Welcome to this latest episode of Canonically Speaking. I'm pleased to announce that my guest today is Fr Brian Austin, who's a member of the priestly Fraternity of St. Peter, or FSSP, who exercises sacred orders in the Archdiocese of Atlanta in the state of Georgia. He's part-time professor at the Canon Law Faculty at St. Paul University in Ottawa, and adjunct professor at the Emory University School of Law in Atlanta. He holds degrees from St. John's College in Annapolis, Maryland, from St. Paul University in Ottawa, and the Katholieke Universiteit Leuven in Belgium, where he obtained a JCD and a PhD in Canon Law. As such, Fr Austin is qualified to serve as an advocate or procurator before any diocesan or religious tribunal in the world, and he can be appointed to serve also before tribunals of the Roman Curia on a case-by-case basis. Fr Austin is a specialist in penal and religious law, and his academic work focuses on questions of legality, due process, and the equal protection of rights. For a long time, he's served the Canon Law Society of America, and he's contributed to several academic journals, such as the Jurist, Roman Replies and Advisory Opinions, and Studia Canonica. So, Fr Austin, welcome to Canonically Speaking. And I thought we could start by picking up on some of those areas in which you have special expertise, starting perhaps with what is known as the principle of legality, and why this is important in canon law, and indeed in any system of law.
Wonderful. Well, first, thank you so much for having me. So in the broadest sense, then, the principle of legality and its simplest formulation would be something like simply the submission of the ecclesiastical authority to the law. That would be its basic formulation. Another way to say it, in our Anglo-American common law tradition, we speak of the rule of law, which is a very similar concept, and also the due process. These are our Anglo-American formulations, very similar. So basically, is the authority adhering to the law as promulgated, and that's the basic understanding of legality.
Can you give any examples of how this might apply in the practical application of law?
Sure. It probably most often comes up in administrative law when, for example, something like a parish closure, let's say the bishop decides to close a parish, and there are certain things the law requires him to do before he does that. For example, to consult the people whose rights might be harmed in the College of Consultors and things of that nature. And if he makes a decision that doesn't follow the prescripts of the law, that could be challenged before the signatura, and that's Canon 50. I know you had Professor William Daniel on an earlier episode. That's certainly his expertise in his area, but there is a basic procedure provided for in the 1983 Code of Canon Law, which allows certain administrative decisions to be challenged before the signatura. And of course, like the European courts of cassation, as they are called, the signatura does not directly look at the merits of the decision. Was the decision to close the parish a good one or a bad one? It doesn't consider that. It would only consider, in most cases, did the authority follow the prescripts of the law when he came to his decision? So a review of the procedure rather than the merits of the case.
And we'll come to the penal law of the Church a bit later on, the criminal law, but presumably this has got some very direct applications in wanting to prosecute people for crimes or alleged crimes.
Certainly, yes, absolutely. In the penal area, or crimes or delicts, as we call them in the Catholic Church, in the canon law, there's a more specific version of that principle of legality. So these principles of penal legality, we say. So it's the same idea, but then we have very specific things that are provided for in the law. So the first one is, the most important one probably, is on the non-retroactivity of substantive law What does that mean? That simply means that this is really a principle from the natural law, but it's been embraced by almost every single secular legal system as well, that one can only be punished for a crime if that crime was established as such in a law that was sufficiently clear and promulgated, that was an offense at the time that the alleged activity occurred. So the principle of non-retroactivity, that would be one of the big parts of it. The other things are, of course, again, in Anglo-American tradition, we speak of due process, and we have certain due process guarantees also in the 1983 Code. But a fundamental right, what's been recognized as such in the Universal Declaration of Human Rights, but the fundamental right to a trial, and that's embraced in certain ways. It was embraced pretty strongly in the 1983 Code as promulgated, but unfortunately, primarily due to the sexual abuse crisis, there have been certain erosions of those guarantees, in particular the right to a trial, which at the end of the day, someone accused, now with the new Book 6, at any rate, it could be a lay person, but most often it would be a cleric or a religious. If accused of, for example, the sexual abuse of a minor, very grave crime and a delict, that person who's accused does not have a right to a trial. So this is, we would say, this is an erosion or a kind of a walking back of that principle of penal legality.
So it's a step backwards, you might say, in this revision of the code.
Certainly, yes, that's certainly a step back. It occurred earlier. There was a number of administrative interventions by the Roman pontiff, John Paul II, in the late 90s, and then also in the early 2000s. And at any rate, there's a long history, but in 2001, in 2005, and 2010, special laws were issued for the then Congregation for the Doctrine of the Faith. They have all now been formally promulgated, not only in their special law, but now in the 1980, the Code for the Latin Church. Those have been crystallized, we could say, in the new Book 6 that was promulgated.
So on the question of the new Book 6, would you say that in general terms it is an improvement? What was it really that motivated or necessitated the reform, and has it achieved that, or is it on its way to achieving its purpose?
That's a great question. I think it's still too early to tell. There are, with probably almost any legislative reform, there are certainly positive aspects and ones that are perhaps not positive. On the positive, certainly there are a number of typifications, we say. There are a number of descriptions now of actions that were not criminalized or penalized before. So there were some additions there. For example, there are some new canons regulating financial crimes, such as embezzlement or misuse of ecclesiastical goods. And so those kinds of things. There were some additions also to various those sins against morals, whether that's against the faith or against good morals, as we say. Some of those were already in place, but they were in scattered places, hard to find. Only specialists might have known about them. But over the last 10, 15 years, those have been all collected now into one place. So the Book 6, some of the things that look new, if you looked in the 83 Code, they were already in place, but now they're formally inserted into the code, and it makes it much easier for practitioners and others to look at it. Also on the positive side, in the 83 Code as promulgated, the perception was, and I think it was a misperception, but there was a common perception that the procedure that was promulgated was too difficult to follow, but also that it left too much discretion to the authority, that he didn't have to, the bishop, for example, he didn't have to investigate if he thought there were other ways of dealing with the allegation, or he didn't have to impose penalties if he thought, again, if there were sufficient reasons to think that it could be dealt with in another way. It gave the authority a lot of latitude or discretion, as we say. And that discretion is good, but of course it can be abused, or it can be abused by not applying the law. So my own opinion would be that, and this was something that others in the Roman Curia also expressed to those who were revising the Book 6, that what we might need more would be an instruction on how to follow the process. Subsequently, we have received something like that. But sorry, not to get too off track or what have you, but still on the positive aspects of the reform, there's much more clarity now on when the authority, let's say the bishop, needs to conduct a preliminary investigation, and then after he has done that, what he needs to do. And so it's much more directive, so we say, so not rather than leaving it facultative or open to his own discretion, there is more, we say, preceptive language. It's more of the language of command. The bishop is to institute a preliminary investigation. He is to conduct a penal process, whether judicial or administrative. If the accused person is found guilty, he is to impose such and such penalties rather than leaving it very indeterminate. So these are all positive aspects, in my opinion, and also I think in the opinion of the literature. Maybe some of in terms of things that perhaps were not done so well, there is not a continuity between the special law for the now dicastery for the doctrine of the faith, the special law that was promulgated right after Book 6, formulates these delicts in language that is not identical to what is in the new Book 6 as promulgated in 2021. And so that has raised some concerns and questions of interpretation, a bit difficult. The most problematic aspect there in Canon 1398 is the new typification for an offense, a delict, against a vulnerable adult. This is a new typification of an offense, and there's not a clear understanding in the doctrine about what that means. And so that is one problematic aspect that needs to be worked out in the doctrine or the jurisprudence. But of course, there's so little published jurisprudence on these matters that makes interpretation very difficult.
Now, another area in which you are expert is what we might call the intersection of ecclesiastical and civil jurisdictions, in which both the church and the state have a legitimate claim to jurisdiction, matters coming under the heading of mixed forum. And I suppose that a lot of these are the result of the church having a very broad competence for a wide range of matters in the Middle Ages, not only spiritual matters such as sacraments and moral offences, but also many issues that we'd now call civil, such as wills and marriage and education and so on. Can you talk a bit about the mixed forum today and the kind of challenges it presents?
Yes, you're exactly right, of course, for historical reasons. When the church had much more, we might say, political authority, the decisions of her ecclesiastical courts were often recognized in the civil realm. Basically, since the 19th century on, that's mostly gone away, but there are still kind of remnants. And even in the 1983 code, there are several kind of jumping off points, you might say, where it indicates where the church law might defer to the civil law. Of course, we think in the first place of matrimony. And for example, in Italy would be an easy example because of a concordat. So the church law will defer certain things to the civil law. For example, separation of spouses, what happens there. In Italy, the church will say you can either approach the civil magistrate to talk about separation, or you can approach the bishop and request a separation of spouses. We're not speaking of divorce or anything, just a separation. So that would be an example of where both fora, or both authorities, are competent, the civil, and both would recognize the judgment of the other. And that's the very interesting thing about the mixed forum, where both authorities, state and church, are competent, not only competent, but recognize the competence of the other. So we might call that a two-way recognition there, or cause a mixed forum there. That is also the case with contracts. Contracts are usually the church simply defers to the civil law, even though she says she has the authority to review contracts. Ecclesiastical ones, you think between let's say a religious order takes over the administration of a parish. Well, they draw up a contract to determine the responsibilities and obligations and rights for both parties. That's a contract. It can be regulated either by the ecclesiastical law or by the civil law. And in fact, it's regulated by both in different aspects. And so there's that.
Now, one fascinating and in many ways bewildering instance of the overlap of jurisdictions is the case of Cardinal Giovanni Angelo Becciu, formerly substitute of the Secretariat of State, who was tried before the Vatican City State Tribunal on charges related to financial misconduct, specifically the use of Vatican funds in the purchase of a property here in London, plus alleged embezzlement and abuse of office. And I understand this is the first time in history that a cardinal has been tried by a lay tribunal in the Vatican while remaining a cardinal. So this case highlights the intricacies of the dual legal nature of the Holy See and the Vatican City State. Could you enlighten us a little bit or guide us through the maze?
Yes, it really is a maze. I'll need Ariadne's thread. It's quite the labyrinth. So you're absolutely correct. One of the things, just to begin, is that at the time of the alleged offense of the cardinal, still the fundamental law of Vatican City State reserved trials of bishops and certainly also cardinals to an ecclesiastical tribunal of cardinal bishops. It was reserved, his judgment was reserved to clerics because of, we would say, privilege. I'm putting that in scare quotes because that's a complicated thing, but it would be considered, as it were, a privilege of cardinals, even though it was established by a special law. And so that was the first hurdle, you might say, to be cleared. And we get into difficulties already, but not to go down that rabbit hole too far. But Pope Francis had changed the law 4 different times during that first instance trial of the cardinal. And one of the things was what I just mentioned, that the judges could be, in fact, laypersons appointed by the Pope rather than clerics. So that was the first change of law. At any rate, that wasn't really your question. What we see there in the mixed forum is that so Vatican City State, of course, was something that's established at the Treaty of the Lateran in 1929. Its purpose, of course, was simply to supply a body, you might say, an apparatus, to defend and promote the moral person of the Holy See. And so that's the spiritual reality, of course, the Catholic Church. And at any rate, so the Holy See, you might say, is the essential or the soul, and the body it happens to inhabit right now is Vatican City State by the Treaty of the Lateran. That treaty was revised after the Second Vatican Council in the new code in 1983. We had the new code of canon law, and in light of those developments, the freedom of dignitatis humanae, one of them, certainly freedom of religion, but also on the renewed recognition of the competence of the laity. Of course, the 1983 code was revised, and based upon those principles, the Treaty of the Lateran also had to be revised, and it was in 1984. The reason I mention that is because you have this very interesting trial now with Cardinal Becciu, which is under appeal, so we'll be going to second instance, or is at second instance right now, where the fundamental law of a civil power, Vatican City State, says that its first source, or its first font of law, is the canon law. And so it canonizes, we could say, it canonizes the canon law as its first principle of its own state law. And then, of course, it has its own state law to regulate it. And so this is very interesting intersection. It's the unique one where, of course, the Pope is sovereign both over the Holy See, of course, as the successor of St. Peter, Vicar of Christ, but he's also a temporal sovereign of Vatican City State. So he holds both swords, you could say, the two powers. He's the supreme authority in both of those realms. And that's a very difficult position. Of course, it's unique and so presents unique challenges.
And we await developments on that. I understand that you're actually working on the translation of a book. Is this still in the course of being translated, or have you finished it?
Yes. So, yes, there are 3 professors at the University of Bologna, and the one who was really spearheading it her name is Geraldina Boni. She didn't know Cardinal Becciu at all before, but his defense team reached out to her because she's an expert not only in the canon law, but also, as we say, the ecclesiastical law, which is the law of Vatican City State. So she has degrees in both of those, and she's a full professor there at Bologna. So they had reached out to her to write Amicus Curiae, a defense brief for the cardinal. And so that developed into a book, and which was published just this year. And yes, so I reached out to her. Long story short, it took me all summer, but I completed 2 books that she had published on this principle of penal legality was one, and then the other on the trial of Cardinal Becciu. And so those 2 volumes in Italian will come out, God willing, later on this year from Wilson and Lafleur, and in English, and it will be a kind of a 2-in-1 volume.
We look forward to that. And if you give me the details later, I'll put it in the show notes.
Sure.
Now, if we might, can we turn to your own role in the world of canon law? I mentioned at the start that you're a member of the Priestly Fraternity of St. Peter, or FSSP. Could you talk a little about the origins and historical context of the FSSP and its charism and its purpose nowadays?
Sure, my pleasure. Of course, after the Second Vatican Council, the new liturgy was still being revised, and it will be promulgated, we could say 1970, let's say, but then there were other revisions, but for the sake of simplicity, the new form of the liturgy was promulgated. And at that time, one of the council fathers, namely the Swiss bishop, Archbishop Marcel Lefebvre, asked the Holy See if he could continue to celebrate the liturgy according to the form that it was before, and that's had several names, whether you call it the Tridentine Rite, or for a while it's been called the extraordinary form. At any rate, however you're going to describe it, the liturgy before the Missal of Paul VI, however you want to say that. So he had asked for that permission and received it, and so he was continuing to form priests for ministry with the older form of the liturgy. It's a complicated history, but that went on more or less all right until we got to 1988. And then the Archbishop was getting old, and he thought, if I die, there's no one to succeed me. Long story short, the Holy See had agreed to ordain some of his priests bishops, and there was some disagreement about the timetable and who these priests would be. Of course, a great misfortune. At the end of the day, the Archbishop decided to ordain 4 of his priests bishops without the without the explicit permission of the Holy See. So that act of schism was being seen by about 12. There's about 12 priests and maybe 20 seminarians who saw that this is the trajectory that this was going, and they didn't want to have any part with that. And so they went to John Paul II through the mediation of then Cardinal Ratzinger and asked, look, they explained the situation and said, we don't want to go that route. So is there something that you could do? And they said, yes. And so through the mediation, as I say, of Cardinal Ratzinger, John Paul II erected the fraternity, the priestly fraternity of St. Peter in July of 1988 as a way for those who didn't want to go down that route with the Archbishop Lefebvre. And so now we have maybe 350 priests about worldwide working in, I think, something like 80 different countries and 120 dioceses. Here in North America, we have maybe 110 priests working, and the rest are distributed mostly throughout Europe, but we are also in Australia and New Zealand and other places in the world.
And what would you say its charism is then?
So essentially, the charism of the Fraternity of St. Peter is to form priests according to the older form of the liturgy. That would be its express charism. So the formation of priests according to what we now say the extraordinary form, and then to have availability for any kind of apostolic work that the Holy See or dioceses would invite us to. Effectively, most of the time we are parish priests. We have mostly parishes or chaplains to chapels or to oratories, things of that nature. That's for the most part. There are very few of us. There are a small handful, of course, who would teach at our seminaries, one in Bavaria in Germany and the other in the United States for the Anglophones in Lincoln, Nebraska, and some men at universities, but most of our work would be caring for the faithful, for those who are devoted to the older forms of the liturgy.
And you have special permission to retain the older form of the liturgy because it's part of your founding charism, presumably.
That's right. Yes, exactly. It's in our founding documents, in our constitutions. And then even after that Sionis Custodes of Pope Francis, there were some worries on that front. And so the Holy Father very graciously received a few of our priests who went to have an audience. And he says, don't worry. And he wrote a very nice little rescript, I suppose we would say, just reconfirming, just saying that, yes, please continue in your charism. It's a benefit to the church and to the world.
Now, the Fraternity is a clerical society of apostolic life, of pontifical right.
Yes.
Does that mean that you are diocesan priests, or are you religious, or how do you classify yourselves?
Great. That's a great question. And most of the lay faithful think of those two categories, whether diocesan or religious. And so we're that middle group in the middle, and there are others who think of the Oratorians of St. Philip Neri would be maybe the prototypical example. But basically what it means is, so we're neither diocesan, but neither are we religious, but we're more like religious than diocesan, by which I mean, although we don't formally take the vows as the religious do, we make those same promises of poverty, chastity, and obedience to our religious superior. I say religious, not quite correct, to our, how do we say, to our own superior. And then, so we're subjects to a mixed form, but then we're subject to both superiors, of course. So for example, here, I'm at a residence in the parish here in the Archdiocese of Atlanta. And so the Archbishop of Atlanta is my superior in that sense. So I'm obedient to him. But I also have, we have our own provincial here in North America. And of course, he's my direct superior also. So both and.
Now, before we finish, I'd like to draw attention to your own website, which is appropriately entitled Austin Canonical. Would you like to explain how that came about and the sort of things you're doing through it?
Would love to. Yes. So I have many different hats that I wear. So I help at the parish. I have these different part-time roles at the university, but it's wonderful to have praxis as well as the theory. And I act as an advocate, often for priests. And if there's a priest is accused of something, I'll be his defense attorney, as it were. I'm also advisor to our own provincial here in North America for review of contracts and those kind of mundane things, drawing up letters of appointment. I also am a consultant for a different religious order in the United States. There's some other superior whom I help with religious questions of religious law. So admission of formation of candidates or dismissal or transfer of sisters, that kind of thing. I also serve as a judge at the appellate tribunal in Canada. There's one tribunal only of second instance for the whole, at any rate, for the whole country. So I'm one of the judges there. And at any rate, that's basically, that gives you a broad spectrum. I help with marriage causes also as a defense, a counselor, an advocate. And all of that is there on that website there, describing the different roles that I've had and open to.
Again, I'll put the reference to your website in the show notes. And now it's time for us to draw to a close. So I'd like to thank you once again, Father Austin, for talking to us today and providing us with some of your many insights into the workings of canon law, there's a lot more that we could have talked about, but perhaps we can leave that for another day. So thank you once again, and I wish you well as you continue to provide all the range of services that you do to the world of canon law. So until the next time, goodbye and God bless.
Wonderful. Thank you, Father.
Thank you again to my guest today, Fr Brian Austin FSSP. And thank you to Emma Setiadi for her rendition of CP Bach Solfeggetto, which opens and closes this podcast. I'm Fr Paul Hayward, and you've been listening to Canonically Speaking. Please be sure to subscribe and follow wherever you get your podcasts for more interesting conversations from the world of canon law. Until the next time, thank you and God bless.